Good morning to everyone. It is 9 o'clock. Can you hear me in Pecos Hall?
We can hear you.
Awesome. Thank you. Today is Wednesday, April 9th, 2025. This is a continuation of the Oil Conservation Commission hearing that we have had scheduled for April 7th through the 11th. This is an evidentiary hearing that we're having today. We're continuing it. It's the consolidated cases by Goodnight, Midstream, and Empire, New Mexico. The cases, again, for the record, are case numbers 24123, 23614 through 17, 23775, 24018, through 24020, and 24025. Before we start the actual case and transfer it over to our hearings officer, I just have a preliminary issue that I'd like to discuss regarding tomorrow. Commissioner Dr. Mpoma tomorrow does have a scheduling conflict in the morning, so we do need to start on a delay if at all possible. So the request is to potentially start at 10:30 tomorrow morning. Starting now, it's glitching on my side, so I don't know if you guys heard that, so I'll repeat it. Starting at 10:30 tomorrow morning. Are there any issues with the commissioner, other commissioners? Mr. Lamkin, do you have an issue with that?
I don't have an issue with that.
Excellent. And then as the parties that are in the room as well, I always start on my right-hand side, Mr. Rankin.
Good morning, Mr. Chair, Commissioners. No problem accommodating Dr. Mpoma's schedule.
Excellent. Thank you. Ms. Hardy.
Good morning, Mr. Chair, Commissioners. That's fine with Empire. Thank you.
Okay, Mr. Beck.
That's fine with Rice. Thank you.
Okay, Mr. Moander.
No issue from OCD, Mr. Chair.
Excellent. And on the platform, Mr. Suazo.
No issues for pilot.
Okay, so we will be starting tomorrow at 10:30. So that is going to be a slight shift to our normal schedule, but thank you for everybody's willingness to accommodate. That was the only thing that I needed to talk about. So, Mr. Hearing Officer, I transfer the hearing over to you again. Thank you.
Thank you, Mr. Chairman. You're sounding better. I hope that's the case.
Thank you. I appreciate it. I'm trying.
All right. With the commission's permission, since the weather is warming up nicely this week, if it's okay with you, Chairman Rosatos, I'm inclined to relax the dress code. If folks want to take off their jackets, feel free to be comfortable. We've been here long enough to indulge that sort of informality. All right. I see.
I'm totally okay with that. Commissioner Mpoma already has his jacket off, so make yourselves comfortable.
Okay, great. Thank you. All right. Well, I see we have a witness back on the stand, and we have a court reporter who's rested and raring to go. Mr. Wheeler, you're a lawyer, but so it's probably pointless, but I'll remind you, you're under oath as well as an expert. Let's see.
Well,
Let's go back on the record if we aren't already. And I believe, if I'm not mistaken, Mr. Beck, it's your cross-examination of Mr. Wheeler.
Morning, Mr. Wheeler.
Morning, sir.
My name is Matt Beck, and I represent Rice and Permian.
Yes, sir.
In your testimony yesterday, you said that Empire became aware of injection of salt water into the San Andreas in 2023. Is that right?
Just a minute. Something's ringing, but I don't have my phone. Sorry.
That's right.
It's ringing in my new hearing aids, so
No problem.
I'm searching on my pockets and can't find anything. Thinking this is a terrible way to start, so hopefully it'll improve now.
Great. So how did Empire become aware of the saltwater injection into the San Andreas and the EMSU in 2023?
Our chairman and Mr. West went up to review the properties and talked to the field foreman and stuff about the process to go in and rework the field and improve the production stuff. And the story I heard, which is really a great story, it turned out to be false, was that they were flying over in a helicopter and saw the operations. But I was correct and told they were just driving around in a car. But anyway, that's when they saw the Wrigley surface facility there at MC.
The Wrigley surface facility, you said?
Yes, sir.
Is that a Goodnight injection facility?
Yes, sir.
Now, I assume you're aware of what the Eunice Monument Umont saltwater disposal system is? No.
Yes, sir.
And you understand that to be a saltwater disposal system operated by Rice?
Yes,
Is that
sir.
right? And Adam, can I ask you to bring up Rice Exhibit 4? This is Rice's Exhibit 4, Mr. Wheeler. Have you seen this document before?
No, sir.
Okay. You know who Thomas Pritchard is?
Yes, sir. He was the former chairman.
And so this is a joinder and ratification of Articles of Agreement of the Eunice Monument Umont Saltwater Disposal System.
Yes, sir.
And it says that in exchange for the mutual promises and covenants contained in the foregoing Articles of Agreement for the Eunice Monument Umont Saltwater Disposal System and other good and valuable consideration, including acceptance of Empire New Mexico LLC as an additional and new system partner with the right to dispose of saltwater by use of the system, the receipt and sufficiency of which is hereby acknowledged, Empire New Mexico LLC as an additional and new system partner in the Eunice Monument Umont Saltwater Disposal System does hereby adopt, accept, ratify, and agree to be bound by all of the terms and conditions, including the assumption of system liabilities of its assignor, all as set forth and contained in the Articles of Agreement. Did I read that correctly?
Yes, sir.
And this was executed by Thomas Pritchard as CEO of Empire New Mexico on November 29th of 2021. Is that right?
Yes, sir.
Do you know where and I'm going to call it the EME instead of Eunice Monument Umont. Do you know where the EME saltwater disposal wells are within the EMSU?
Yes, sir.
And so this would indicate that in November of 2021, that Empire was aware of ongoing saltwater disposal into the San Andreas within the EMSU and around the EMSU. Is that right?
Yes, sir, it should.
And are you aware that, can you bring up Rice Exhibit 1? And before I leave this one, Mr. Hearing Officer, Rice and Permian move to admit Rice Exhibit 4 for admission.
Empire?
No objection.
Goodnight.
No objection.
OCD,
No objection.
Pilot.
No objections.
It'll be admitted.
Now, Mr. Wheeler, I'm showing you what's been marked as Rice Exhibit 1. If you do you recognize this? Well, first, let me ask you, have you seen this articles of agreement for the Eunice Monument Umont saltwater disposal system before?
Yes, sir.
And these are the articles of agreement that Empire joined in November of 2021, right?
Yes, sir. We were successor interest in Gulf, which later became Chevron, and then was transferred to XTO, which we succeeded in.
And so on page 1 of this document, this agreement was made between the system parties on June 10th, 1958, right?
Yes, sir.
And those founding parties in the system included Gulf Oil Corporation.
Yes, sir.
And that was the successor and interest, as you just said, to Empire via XTO and before that Chevron.
Yes, sir.
Mr. Hearing Officer, I'll move to admit Rice Exhibit 1 into evidence.
Empire. Empire.
I'm assuming, I'm sorry, I checked out there for a sec. I'm assuming you're admitting this last exhibit?
Yes.
Wait, no objection.
Goodnight.
No objection.
OCD.
No objection.
Pilot.
No objections.
It will be admitted.
Thank you. Mr. Rankin, if you go to page 2, paragraph 2 of that. This provides that it being desirable that a unified effort be made to control the disposition of the water produced from the wells listed on Exhibit D. It is the purpose of this agreement to prescribe the manner in which a unified disposal control system for the water so produced is to be constructed, operated, and maintained. Did I read that portion of it correctly?
Yes, sir, you did.
So the purpose of this was so that the parties could dispose of wastewater produced in their wells in the EME system, right?
Yes, sir. It's only the parties that are related and listed in the first paragraph. And it was not a commercial disposal. And the disposals were not at hundreds of thousands of barrels a day for that operation.
Okay, so I didn't pick up on that when you were talking yesterday about commercial disposals. This was not included in those commercial disposals, the EME system. Okay, and talking about production, you're aware that the EME system operates on vacuum.
Yes, sir.
And it's operated on vacuum since, well, the late 1950s until today.
Yes, sir.
Mr. Wheeler, I'm going to ask you to pull that mic a little closer to you if you don't mind.
Closer.
Thanks. You're not the only one here with hearing issues, so. And by the way, we have these if you think that would be helpful to you. They're more at the back.
I've never done anything with that, so I would probably be really in bad territory.
Mr. Rankin, if you'll go to page 33, that Exhibit 1, please. Mr. Wheeler, this is Exhibit D of Exhibit 1, which is the EME Articles of Agreement from 1958. Do you see Gulf Oil Corporation's wells listed
sir.
there? And that includes the Bell A through G and then the Ramsey A, right?
I can see the Bell, but I don't see the Ramsey. But
That's fine. It's
I
underneath
trust you
Bell G.
no, I trust you. What you're saying is correct.
All right. And then Gulf Oil corpse wells listed in Exhibit D, then continue on to the next page, almost the entire next page of Exhibit D, right? The wells that are part of the EME system.
Yes, sir. I don't recognize the names because after the unitization, all those names were changed, but I see the list.
Okay. And I want to go to the second slide in your testimony from yesterday. So yesterday, when you talked about the Commission's 1984 approval of the EMSU water flood and definition of the unit to include the San Andreas in 1984, at that point, the EME system had been operating for over 20 years, right?
Yes, sir.
Disposing of saltwater, produced saltwater into the San Andreas for over 20 years.
Correct.
The next thing I want to talk to you about is slide 7. You talked about the first bullet point on slide 7 here a little bit yesterday. And I think I like Mr. Rankin noticed this was different than what I read in your direct testimony. And so last night I went and looked for.
I'm sorry, I can't see a slide.
Is it not in front of you on your computer screen there?
Oh, the acquisition. Okay, I'm sorry, I see it.
That's all right. So I went yesterday and looked through the purchase agreement for a document or exhibit called Assumption of Minimum Estimated P&A Liability or something like that, but I didn't see that. Is that part of the purchase agreement, or was there a separate agreement for that?
In the XDO agreement, it's stated in there that as part of the agreement, there's an assumption of all plugging and abandonment liabilities for the wells that were assigned. Sharon, we had that highlighted in the purchase and sale agreement, so maybe you can help Mr. Beck locate that.
Was that Article 11 that you talked about with Mr. Rankin yesterday, the post-closing obligations?
Yes, sir.
Okay. And when did Empire become aware of the $56 million in plugging liability?
Well,
If you know, I recognize you weren't there in 2020 when this was all going on.
what transpired was that Mr. Pritchett had done the purchase and sale agreement and executed it, and then executed all the additional documents, and he put them into a file that was not a share file. And right after the acquisition, he left the company. And it wasn't until we were doing the due diligence for responding to the subpoenas that Goodnight had tendered to us did we go through and have an outside firm come in and try to locate all of his emails and share our files and everything. And that's when we really focused on how large the liability was. And about the same time is when we got the order of compliance from the OCD, from Mr. Jesse Tremaine, where he listed the wells that we were out of compliance on and needed immediate action on.
So it was in responding to Goodnight subpoenas that Empire became aware of this plugging liability of now 56 million.
Yes, sir. We had wells that we knew had gone offline and needed plugging or recompletion, whatever, about the time, I would say in May or June of 2023, when Mr. West came aboard and he went out to the field and stuff and everything with Mr. Mullichek in August of 2023 and recognized the number of wells and the fact that many of them needed plugging and action taken to correct it.
And recognizing that in August 2023 is when you all engaged, I think you said like an outside firm to look at the extent of that liability. Is that right?
Yes, sir.
And that August 2023 time period, that's about the same time that you got the notice of or order of compliance from the OCD.
Yes, sir.
And that's how you came to recognize what you now estimate is $16 million of surface remediation.
Yes, sir. There were over 700 wells that, not that date, but in the future, as long as Empire owned the property, that we would ultimately have to plug and remediate the sites.
Now, if we look at, and I think you looked at this yesterday with Mr. Rankin, if we look at paragraph 10 of your direct testimony from 2024, that's where it was a little bit different. Well, it was really different. And in your August 2024 testimony, you said Empire acquired basically the properties from XTO for $17,800,000, right?
Yes, sir. I went back and looked last night on my notes and stuff. And when I'd given it to my paralegal to type, it was in my notes to her, it said for a cash purchase price. And when she typed it and I reviewed it and stuff to execute it, I didn't notice that the word cash had been excluded.
And you looked at those notes last night, you said?
Yes, sir.
So those would be available to provide to all of us here?
Yes, sir.
All right. You'd be willing to do that?
Subject to my counsel's guidance.
Okay. You'd be willing to provide us at least the portion of your notes that said a cash purchase price?
Yes, sir.
I'd like to see that. Now the next sentence you didn't talk about, the next sentence of paragraph 10 says, because of this substantial investment, it is imperative that Empire be allowed to conduct primary, secondary, and tertiary recovery of all hydrocarbons present in the Eunice Monument South Unit. Is that right?
Yes, sir.
Is that what was written in your notes that you reviewed last night?
And I didn't look at that sentence and stuff, but that is proper and correct to the best of my knowledge.
And so what this sentence is saying is look, we spent almost $18 million on this property. And so because of that substantial investment, it's imperative.
Sharon, can you turn off my phone or something? I can try to take my hearing aids off.
That's
doesn't-
fine. No worries. No, I think she turned them off. Can you hear me now?
Yes, sir.
All right. So what I was getting to is that second sentence is telling the commission that because of this quote substantial investment, it's quote imperative that Empire be allowed to conduct primary, secondary, and tertiary recovery, right?
Yes, sir.
And now, come to today, as you represented to the commission for the first time yesterday, you're now saying that it wasn't $17.8 million, it was $89.8 million, right?
Yes, sir.
Because now, in 2023, you recognize that this property you bought for $17.8 million came along with, well, at least an additional over $70 million in liabilities.
We did in terms of estimating the cost of the P&A liabilities, which was 56 million. And then following my preparation and execution of this self-affirmed statement, we received a notice from the State Land Office that there were 288 sites that we needed to remediate that we were not aware of either. But if you go back to the purchase and sale agreement, instead of what I always try to negotiate in a purchase and sale agreement is that you'd have an effective date and you would assume all the liabilities after the effective date, and the seller would still be responsible for all the activities prior to the effective date. But if you look at this purchase and sale agreement, it provides that we're responsible for all the costs associated with any operations or work or anything prior to, on, or after.
So I think the answer to my question was yes.
Yes,
That after that date, where you wrote 17.8, you found out that Empire in 2023 now had an additional $72 million of liability, at least with these properties.
in 2024 would be the date that we were totally aware of all the costs.
And going back to that second sentence of paragraph 10, there's nothing preventing Empire today from conducting primary, secondary, and tertiary recovery of those hydrocarbons, is there?
Yes, sir.
And what is that?
The injection of the commercial wells that are within the EMSU unit and the high volumes of water that they're injecting, which is detrimental to a tertiary recovery operation.
Well, just looking at what you say in paragraph 10, there's nothing, I mean, Empire right now is allowed to conduct primary, secondary, and tertiary recovery, right?
Well, we would have to go to the commission and get approval for a CO2 flood operation. And at that point, if they approve it, we would be able to conduct tertiary recovery.
And that hasn't happened yet.
No, sir, it hasn't.
Empire hasn't applied for that.
No, sir, we haven't.
When you talk about, and I wrote this down yesterday, you said that you were ordered to stop doing anything with the EMSU. Is that right?
We had an executive meeting as to the operations, and the determination was made that we were not going to expend any more money until we were able to cease the injection in the commercial wells. And if you talk to Mr. Curtis, you'll see that we also have gone in and terminated all of our interest in any of the Rice and Permian saltwater disposal agreements that Mr. Pritchard had executed.
Do you remember my question?
Would you repeat it?
Yeah, it was yesterday. You said that you were ordered to stop doing anything with the EMSU, right?
Yes, sir.
And you sort of got ahead of me there, but I was going to say that order came from Empire, not from anyone else outside of Empire, right?
That's correct.
And you've adhered to that. You haven't done anything else with the EMSU in terms of further development here, right?
Yes, sir.
You haven't taken any cores of any wells?
No, sir.
You haven't taken any mud logs of any wells?
No, sir.
You haven't taken any logs of any wells?
No, sir.
You haven't drilled any new wells into the San Andres to test for new oil?
We, for the lawsuit, we had proposals to drill 3 new wells that would go down into the base of the St. Andreas and would give us information and validation of our position. We started in January. We filed, I think, 2 permits with the state. We've acquired surface agreements for damages to go in and conduct the operation, but we haven't drilled any of those 3 wells as of this date.
When did you file those applications for those 3 new test wells? You don't have to give me the exact date, just any idea of the timing? Was it this year? Was it last year?
No, sir, it was, I'm thinking in February or March.
February or March of this year?
Yes, sir. I could consult with Mr. West or Mr. Davis to find out, but that's what my recollection is.
That's fine. So February and March of this year is the first time that you took any step to get to drill a new test well, right?
Yes, sir.
And you haven't taken any other step to get new logs,
No, sir.
mud logs?
Well, just what was available that we were able to locate.
Yeah. What was available, meaning what was available and what you've provided to the experts who testified for Empire so far?
Yes, sir.
Right. And I think I've seen you. There's been a lot of people in and out, but you've been here for all the testimony of Empire's witnesses so far over this week and a half.
Yes, sir.
And you've heard each one of those witnesses say, your consulting expert witnesses say that they would have benefited from more data available.
Yes, sir.
Including Mr. McShane yesterday about more recent logs, mud logs, of course.
Yes, sir.
Now, also in February of 2025, this hearing started in front of the commission, right?
Yes, sir.
On February 20th, 2025.
That's at the last week of February.
And you talked about a letter sent to Mr. Curtis. That's Scott Curtis, the president of Rice Operating Company, right?
Yes, sir.
And that letter was intended to get Empire out of the 3 saltwater disposal systems it was a party to for Rice, right?
Yes, sir.
And that letter was sent on February 21st of 2025, right?
Yes, sir.
The day after this hearing started.
Yes, sir.
That's all I have.
Thank you, Mr. Beck. All right, cross-examination by pilot.
No questions from pilot.
Then we're back to the commission. Dr. Homa, I will start with you.
Thank you, sir. Good morning, Mr. Wheeler.
Good morning, sir.
Thank you for your testimony today. So earlier on, you were saying that Empire was not aware of any saltwater injection going on, let's say within the EMSU, prior to execution of the purchase agreement. Do you still stand by that?
Yes, sir.
So do you agree with the statement that the San Andres has commonly been agreed to be as an aquifer within the EMSU?
No, sir, I don't believe it's an aquifer. I see it as a unitized interval within the MSU.
So
Maybe I didn't understand your question right if you wanted a different answer, so.
yeah, so as part of the opening statement, Goodnight was saying that the San Andres was more or less erroneously included in the unitization. So it has normally been classified as an aquifer.
Okay,
So I was asking, do you believe that statement?
yes,
Do you believe that?
as you stated, I think that could be a correct position.
Okay. Now, let me ask. So if Empire knew about these saltwater injection that was going on within the EMS area, would that have impacted the sale agreement between STO or Chevron and Empire?
To my knowledge, there wasn't any agreement with Empire and any other party other than Rice Operating.
Let me repeat my question one more time. So I'm just following up from my previous question where you said that Empire did not know about the ongoing saltwater injection in the EMSU.
Not till August of 2023, yes, sir.
Okay. So my question to you is, if Empire knew about the ongoing saltwater injection within the EMSU, specifically into the San Andreas, would that have impacted your purchase agreement?
If we had known it prior to making an offer to purchase the properties, we would have never done it if we couldn't cure the issue with the commercial disposal wells that were injecting into the St. Andrews. That's correct, sir.
Then is it not that probably Empire did not do a due diligence?
No, sir, like I stated previously, we engaged a company called Elk Mesa Energy in Denver that took the dump file from ExxonMobil, and they were analyzing all of the data and everything. But there was no information in there that disclosed that there were any saltwater disposal wells that were injecting into the St. Andreas.
I mean, that one is a little bit difficult for me to understand because even, let's say, you're going to put up over $17 million to make a purchase of a property. I mean, even if we are buying a rental property, if we are buying a rental property, we do have the right to go out there, scout the area, even enter the building to know what we are really signing up for. So it's a little bit surprising that you're saying that Empire got to know about it probably two years after the purchase.
If you read in the purchase and sale agreement, it provides explicitly that we would have the right to go out on site and investigate the assets and everything. But at that time, Empire was a very, very small company with less than 5 or 6 employees. And we engaged Elk Mesa to go in and do the analysis. And when I talked to the lady at Elk Mesa, she said that they had not done an on-site visit. And when I talked to Mr. Morissette, who's the only individual that's still with Empire from the date that we acquired the property, he had no knowledge that an analysis had been done of going on site and reviewing the properties.
Then it sounds to me that you're trying to utilize the commission and also like the cost to more or less rewrite some wrongs that Empire should have probably known better.
Yes, sir. When I've done, and I've probably done 600 to 700 acquisitions in my career, and every single time my approach to the due diligence was significantly different than what I've been able to determine that Empire did back in 2021.
So you talked about in your direct testimony, and I know there's been back and forth. So you're talking about, I'm just going with whatever on the item number 10, where you're saying that you do have you've already spent $17.8 million, and the commission should, which is a substantial investment, and it is imperative that Empire be allowed to conduct primary, secondary, tertiary recovery of all hydrocarbons present in the EMSU unit. Now, my question to you is, do you have any knowledge on the saltwater injection investments that has occurred in this area since, let's say, 1955 or so? So if, let's say, the commission is to grant fully what Empire is asking for, do you have knowledge on how much investment will be wiping out?
No, sir. I do know that they have a pipeline that I think is about 60, 70 miles long that goes up into Lee County in the area of the MSU. I also know that they drilled 4 wells, of which the first well, the Rhino well, was drilled down into the Devonian, which would be a very expensive well. So my estimate would be that the wells that they drilled plus the facility and stuff could be in the range of $8 to $10 million.
$8 to $10 million?
Yes, sir.
I mean, to drill to Devonian is about 18,000. Are we talking about the same 18,000, 20,000 feet of Devonian?
Yes, I don't know.
Yeah, I mean, the Devonian, as I know, is over like 18,000. I don't know this, let's say in this particular area, 18,000 to like, 20,000 feet. And even if you are drilling 1,000 per foot, I mean, that's close to like $18 million for that Devonian well.
Okay, thank you for the information.
Yeah, okay. And it was a little bit concerning yesterday. You talked about this is not the only case that you are bringing up to the commission. You're going to go after the other units in that area. And I'm just thinking about all the total investment, that is going to be wiped out if the commission more or less is to proceed to grant Empire fully what you're asking for. Now, so when you got to know about, and Zach, you can stop me if I'm beyond my reach here. So when Empire got to know about the saltwater injection that is going on in the EMSU, was there any discussion with the seller?
Yes, sir. We spoke to several people at XTO in the land department, the geology department, and inquired about the knowledge and information they had. And their response from each of those was that they did not have any knowledge of the wells being drilled inside the unit.
So this is specifically to the Goodnight wells.
Yes, sir, the Goodnight wells. They were not aware of them or the well that Permian had drilled in 2020.
Okay. Okay. Now you talked about Goodnight's conduct. You talked about Goodnight's conduct, on one of your slides.
Yes, sir.
It sounds to me that your case is much bigger. From what you said yesterday, that you are not just going after Goodnight. You are not just going after the EMS. You're going after all the other ones, and the commission, you are putting out on notice that is coming, right? So is it only Goodnight that has permits to inject into the San Andres in all these areas?
I don't have the list in front of me, but I think it's a total of maybe 6 wells, 4 of which are the Goodnight wells that are currently injecting, that we're going to try to go before the commission and be able to get orders to allow us to do our tertiary recovery operation and save the minerals that are existing in the residual oil zone in the St. Andreas.
So when you say that XTO did not, let's say they said they were not aware that these wells were drilled in 2020, I mean, were they not provided notices, or you are not aware of that?
In talking to the people at XTO, none of them acknowledged receipt of those notifications. What they told me was their thought process was that if they had been sent, because the property and the asset had been transferred from XTO over to the ExxonMobil divestiture team, that anything that would have come in related to the MSU unit in the mail or whatever would not have gone to XTO, but would have been forwarded to the divestiture group at ExxonMobil, whose sole purpose was to sell the asset, not to do any additional expenditures or anything in response to, for example, the saltwater disposal application.
So, sir, is it your testimony that so you purchased the asset around March 12, 2021, and these wells were drilled in 2020. So are you saying that within that period, XTO more or less shut down all the operations in the area?
Is that what I'm requesting?
Yeah, so are you saying that they were not operating? The entire area was shut down? Nobody was on site?
There were field people that were with pumpers and operators that are and in the Eunice field office that handled the property, but none of them were in-house. They were all just field people and pumpers that were working.
You know, the reason why I'm saying that is that, in a normal oil and gas operation, when we are drilling a well, so I've drilled one well in the San Juan Basin, and as we're drilling the well, we had the mineral owners, operators in the area, Hillco, for instance, came around to check out what is going on, in our backyard. So it's surprising when you say that 4 wells have been drilled in your backyard without anybody knowing about it. I mean, that's
Well, the pumpers and the field hands did, but I'm just as curious as you are.
okay.
I would go out and check and see what's going on and how and why and everything. So to drill those wells, it would be very impossible to conceal that.
Yeah. And you were a lawyer too. So let me ask you this. So there have been a talk about it has never happened where an operator who do not have an interest in unitized unit be allowed to inject into, let's say, any structure within that. Is it illegal?
Never in my career have I done that, because what the issue is that you have the first week of law school in oil and gas, you learn that there's air rights, surface rights, and the mineral rights. And you learn that the mineral rights are the dominant estate. And therefore, no activity can take place which infringes upon the mineral rights ownership. So the surface owner does not have any authority or right or privilege to execute a surface lease or a saltwater disposal lease down into your unitized formation. So Empire's position is that Goodnight has no rights whatsoever to drill their wells in the first place. And they never came to the commission and disclosed to the commission that they had no rights to drill those wells. So that's why it's trespass on our property.
Well, so did they permit all the 4 wells at the same time? Do you know?
Yes, sir.
All at the same time. I mean, all the wells that have been drilled now, did Goodnight permitted all those wells at once?
No, sir, I don't believe so. If my information is correct, they drilled the Rhino well first down into the Devonian. They operated that for a period of time, came back to the commission requesting an administrative order to allow them to go and drill and complete into the St. Andreas. And then the next 3 wells were drilled into the St. Andreas. So my thinking is it took a year and a half, maybe even 2 years for them to do all their operations of installing the Wrigley disposal facility and the 4 wells.
So are you also implying that probably NMOCD did not do the proper checks before approving those permits?
No, sir, my understanding of the law and reading all the OCD regulations and everything, it's not the responsibility of the OCD to go out and investigate if they have a proper surface lease or the rights to dispose. That's not the OCD's obligation. Under penalty of law, the operator or the party that's making the application has the burden to disclose all those facts to the OCD so they can make their proper evaluation. And in this case, those notifications were not done properly. There was no notification to the commission that they were drilling into the Eunice Monument oil pool, because it requires you to list the pools that you're injecting into. And what Goodnight elected to do is, rather than list the 3 pools that they're injecting into, they only reported that they were injected into the order number 96121, which was for the St. Andrews saltwater disposal. But they didn't report that they were drilling into the Eunice Monument oil pool or the Eunice Monument gas pool. So they should have listed all 3 of them so that the commission could be aware of what their proposal was.
So when Empire got to know about this, was there any discussion with OCD?
No, so we received after the acquisition an email notifying Empire that Goodnight had proposed the Piazza well, and that was when we started doing all of the due diligence and work to oppose that.
So can you, I know the Piazza case, has been brought up a lot between the discussion between you and Mr. Rankin. Was that application denied by the OCD?
Yes, sir.
Why?
Because they were proposing to drill into a unitized formation, and the division believed that there was a residual oil zone that was recoverable in the Eunice Monument South Unit. Therefore, they denied the application on the basis of those 2 matters.
So are you saying that OCD
I have no clue what that is. Maybe, is it somebody on a platform that's not muted? Or
the witness?
Huh?
Is the witness? Wasn't it?
Oh,
Well, so are you saying that OCD agreed that there is an existing ROZ in the San Andreas where Goodnight was planning the injection?
Yes, sir.
And is that listed in their conclusion? Was that listed?
Yes, sir. I don't know, recalling the order, I don't know if they used the term ROZ, but they did define that there were recoverable reserves in the St. Andreas, that the injection would violate the rights to recover those.
Is that order in evidence for this case?
This is a de novo
It also
hearing,
is all gone. Okay,
so,
okay.
but we have that. If the commission would like it, we can furnish it to you.
Okay. So, is it the concern of Empire? So there, you are claiming that there is an existence of ROZ, but still going back to the conduct of Goodnight, is it the volume that they are injecting that really is a problem for you? That can impede, let's say, any recovery of ROZ, or is mostly they've violated the permit?
It's affecting the ROZ. I mean, if you look in those 4 wells and the surrounding wells that they have within half a mile of the unit, they're injecting up to 200,000 barrels of wastewater per day. If you approve their 5 new application for permits, they're requesting 40,000 barrels of daily injection in those. So you're talking about, if the commission approves Goodnight's applications and decide not to revoke the existing wells, you're talking about in excess of 400,000 barrels a day of injection. And it could be even higher, because on the social well that Goodnight has permitted, there's no limitation whatsoever as to the number of barrels they could inject. So they could be injecting 150,000 barrels a day just in that one well, if it's contingent upon their facility and the pipe and everything and stuff. But that's totally unlimited.
But you are an attorney, so have you seen any order from OCD where there will be no limits on injection or pressure?
There's a pressure, as I recall, without it in front of me, there's a pressure requirement, but there's not a limitation on the barrels a day that can be disposed. Whereas there are other 2 wells, both have 40,000 allowables, and the Dawson is 25,000, and they have an application before the commission right now to also increase that to 40,000 barrels a day.
So, after Empire knowing that there is ongoing saltwater injection and there's been numerous volumes of water already being injected into the San Andreas, how risky is your CO2 EOR project, even if the commission grants your petition?
We strongly believe that there is a phenomenal opportunity to go in there and recover the ROZ through the use of a CO2 project. Now, I'm going to speak to this, and I'm not an expert engineer or geologist, but if you believe Exxon's representation that there's 912 million barrels of oil in the residual oil zone, and historically, the CO2 projects that have been on the eastern shelf, and also, for example, on the Hobbs that is on the western shelf, that's a CO2 project, can recover up to 40% of that residual oil zone. So you're talking about 350, 375 million barrels that's recoverable today. And depending on the new technology and everything that is being discovered every day in CO2 floods and operations, it could be even greater than that.
So now I've heard about, so is it Empire position that your recovery factor is going to be about 40%?
That's the lawyer speaking. I'd have to decline my decision to the
Okay.
engineers.
Okay. Okay. And I'm sure Mr. West will testify to all of that, right?
You know, probably when I finish my testimony, I'll be in very bad trouble with Mr. West because I've passed the buck so many times to him.
Then another question for you. So it is the commission's responsibility to also prevent waste, right?
Yes, just present right waste and preserve our correlative rights.
Mhm.
And even more important is the fact that 59% of the unit is owned by the New Mexico State Land Office. So it's imperative that the commission protect the rights of the State Land Office lands and the BLM as the major owners of those lands that they're attempting to destroy.
Yeah, so I will finish my question here. So what is Empire's strategy to prevent waste as in relation to the high volume of water that needs to be produced to even first see the first oil production from the ROZs?
I would have to respond once again. That's probably something you could ask Mr. West that I'm not an expert on.
Okay. So Empire is relying on existing information to prove to the commission that the existence of ROZ, but based on all the testimony that we're seeing here or we're hearing, Empire has not done their own extensive site characterization to really solidify the claims here. So don't you believe that you talked about 3 wells that you're planning to drill? Don't you believe that those wells needs to be drilled to really get more definitive information to be able to solidify your case?
We believe there's enough evidence to date, but I think Mr. Beck was very succinct in his questioning in that each of the witnesses, and I don't know if this is just geologists and engineers, but they never seem satisfied with enough data, and they always want more and more data. So it was sort of like when Dr. Buckwalter was testifying. He had done all of this entry of data into his database, and then it came up, well, did you include perforations? Well, no. So I mean, his whole testimony was torn apart because he hadn't done enough. Whereas he has spent 8-10 months working on it and done hundreds of wells and stuff, and it still wasn't enough for. So
Interesting. So you talk about the interest of BLM and then also State Lands Office. Has any of these entities provided any statement in support of your application?
The application to the commission or
Yes.
application
Yeah,
to
to
drill the new
revoke.
wells?
Yeah, to revoke all the, let's say, the existing injection in the EMSU.
Yes, sir. We furnished the documentation stuff to the commission with our motions to revoke.
So are you saying BLM and State Lands Office have furnished supporting letters to support the application?
Yes, sir, I believe so.
Oh. So is that in evidence?
I would have to defer to my counsel.
Okay, okay. Do you have, as you were going back and forth with Mr. Beck, it sounds like there was some, let's say, documentation in establishing, let's say, injection authority in some of these areas around the area that we're talking about. Do you have any knowledge if such documentation exists for the EMSU who allow injection into the San Andreas?
No, sir, those, like the Eunice Monument Saltwater Agreement that he was speaking of, that was from 1958. And I haven't been able to have, I'm not an expert in the technology with all the things that the young people can do, but I wasn't able to locate anything within the OCD that related back to the commission hearing and the applications and formations way back in 1958. So I don't have knowledge on that.
So the documentation that Mr. Beck was showing to you, is that in relation to the EMSU or is a different area within that premises?
It's within the MSU.
So if it is within the EMSU, Empire also sign up to that immediately after signing closing your deal. So why would Empire do that if they had the thoughts of probably pursuing the ROZ?
Mr. Pritchett just signed a lot of documents, stuff after the acquisition, and I have no knowledge why he had done that or anything about the well. Once again, that was a consortium of oil and gas companies were in the area, and the disposal was just for those wells and those operators. It was not a commercial operation. So I don't have historic information of the volume that's been injected since 1958. But I would suggest to the commission that it was not a tremendously high volume that would have affected. But the other thing is recognize that this was from 1958 and the unit was not formed till 1984. And here I would defer to you as an expert, but I had never heard of CO2 or residual oil zone or anything till the late 90s. So that was 15 years after the unit was formed and stuff. So there was no recognition of the problems that the saltwater disposal into the unitized formation would occur.
So I've been on the commission probably in my fourth year now, and I've seen how the commission do value industry partners coming together to really find solution. And in this case, it is preventing waste. In this case, preventing waste. So that 1955 document you are referring to, don't you believe that solidifies, or that more or less throw more light on the fact that the San Andres at that time was erroneously included in the unitization?
Yes, sir, I would believe so.
Okay. So then, in that case, NMOCD has not done anything wrong if, let's say, they approve saltwater injection in the San Andres from 1955 up until now. Would you agree with that?
Well, I don't think that the commission was responsible. I think it was the division. And because there were no protests at the time, they were administratively approved without a hearing. So there was never any discovery or determination as to the unitized interval that they were injecting into, or the invalidity of their rights to drill from the surface for any agreement with the surface owners, or any disclosure that it would be into the Eunice Monument oil pool. So none of those matters came before the division for them to hear the testimony. So this is the first time that I believe that the commission is being put on notice of that. So the commission, the division didn't do anything improperly. But now with the new evidence, I think that the commission can take the appropriate action. And if the commission determines that they're not going to revoke the 4 existing wells, for example, I would urge the commission to, at a minimum, to suspend the injection at the current time until Goodnight can furnish the commission irrefutable proof from a board certified oil and gas lawyer who could prove to the commission that Goodnight had the right to drill those wells in the first place.
So if I flip that and then ask you that, let's say, if Empire will be willing to say that, okay, commission should suspend, like you said, all the saltwater injection that is going on in the EMSU right now, to give Empire time to prove that the oil, the ROZ, if it is there, is recoverable. Will you be open to that?
That is the most fabulous suggestion I've heard these whole 10 days of hearing.
And how many years will Empire be open to that?
You know, you're getting me in more and more trouble with Mr. West. But I would think we could do it within a couple of years.
So within that couple of years, Empire will have the opportunity to drill the 3 wells
Yes, sir.
and prove to see that if any of these claims, real evidence that the ROZ indeed exists and is recoverable.
Yes, sir.
Thank you, sir. I do not have any further questions for you. Thank you for your time.
Thank you.
Thank you, Doctor. Mr. Lamkin.
Good morning, Mr. Wheeler. Thank you for your testimony the past day. I have a couple of questions for clarification. Do you know where the newly permitted wells are located within the MSU?
Yes, sir, they're in section 17 down in the lower southern portion.
I don't mean the Goodnight wells. I mean the Empire permitted wells, the test wells. that you
Oh.
guys-
There's one down within or in the middle of the 4 Goodnight wells. There's one up on the crest of the unit, which would be on the right side of the existing unit. And then the other one I think is further north. So it would cover a significant area of the MSU to give you the determination if it's limited to one area or if we can prove it up throughout the entire MSU unit.
Would Empire core all 3 wells?
Oh, yes, sir. We've talked about Mr. McShane didn't speak to it, but when we were doing the AFEs for those, they talked about all the 3 different types of coring and stuff, and went out and tried to receive some bids and stuff and everything on that. And some of the figures that came back would be that all the cost of coring and everything would be approximately $800,000.
Okay. So did you say that your timeline for Empire to affect a CO2 EOR project in the MSU would be 2 years post approval from the division and assignment of capital from your investors, or?
No, sir. In Texas, New Mexico did not start approving water flood operations till the late 70s, 1980s. In Texas, the water flood operations were approved back in the 40s. So if you do a timeline from the time period where you get the primary production, then do a secondary recovery, water flood, could be 30 to 50 years. So right now in Texas, the secondary recovery has been concluded, and now there's tertiary recovery. So that's why in the last 10 or 15 years, there's been approvals for the CO2. In the state of New Mexico, I'm not aware of the time frame that it would take, but when I prepared the request for authorization for a CO2 project on some properties that I worked up in western Colorado and down along the Louisiana coast, then those consents took up to 2 years just to get the consents after the order was requested. So I don't know the commission's response to how long they would think that it would take, but it's significant due diligence. One of the key things is Mr. Moander has raised the issue about how our operations and stuff would affect the water aquifers and stuff, and the Hobbs Channel, for example, or the Capitan Reef. So there would have to be a significant amount of research, due diligence. And I would probably suggest to the commission that it's my belief that 3 wells won't be adequate, that they could require us to drill another 3 or 4 more wells to give them the proof that they need to be comfortable to approve the CO2 project. So I don't believe that we get the approval and get prepared to do the CO2 operation in 2 years.
So then, you're talking about the timeline to drill the additional 3 wells or whatever the commission would require is mainly for delineation of the ROC and confirmation of the claims that you guys have made in your testimony thus far.
Yeah.
I'm mainly speaking about if you guys had consent from the commission to establish an EOR project and you had committed capital from your company, what do you think the timeline is in reference to Commissioner Ampoma's question about performing a pilot to verify that the ROG is there and that it's producible?
If you just do a small pilot project and the commission requests it, I believe that we can get it and do it within that 2-year period where we're talking about drilling the wells and coring and then the analysis and everything of that to present to the commission.
Okay. And then I guess my last question is, do you know of any discussions internally to Empire about the possibility of running any experiments to determine whether or not you're seeing fluid migration from the San Andres into the Grayburg or anything like that you could present to the commission that would give us, more data to backstop our decision on?
Yes, sir. In Mr. West's testimony, I think he'll present some of that information and data. And if, as we spoke previously, if y'all did suspend their operations of injection during this period of time that we're doing the research and stuff, we can do additional research and get documentation that would satisfy the commission of that information request.
Thank you. Those are all my questions.
Thank you, Mr. Lampkin. Chairman Rosados, do you have questions?
Thank you. And thank you, Mr. Wheeler, for your testimony. We appreciate it. Commissioner Mpoma asked the majority of my questions, but I just wanted to follow up on what the commissioner asked you. Mr. Wheeler, you stated that you have support from the state land office, written support for this action. Did I understand that correctly?
We've communicated with the state land office. I don't know the degree of approval that they've given us, but it's my understanding that they have stated that their responsibility is for the state lands. And if what Goodnight is doing and is proposing to do would have negative effects on the state lands, then they would be opposed to those continued operations.
And was this something that was submitted into evidence that you know of?
No, sir, as I understanding, it was just telephone conversations or maybe even face-to-face discussions, but I don't recall exactly how that transpired.
Okay, because that's a pretty heavy-duty statement that is made, and this commission would definitely be interested in seeing any communications that were with the state land office and their support of Empire's action in this particular case. So I find it interesting that that's kind of thrown out there, but the information wasn't retained or no communication was maintained from State Land Office on the said matter. So I think that's my only question as well. Thank you.
Yes, sir.
I have some questions.
I was gonna say, Mr. Chandler?
Good morning. I'm going to be looking at the order partially amending the commission's July 2nd, 2024 order with respect to the scope of hearing, because I view that as the jury instructions. So as we come to the close of your case in chief, I want to go through some points. And I will give you this document in just a second. But point number 2 says the granting of applications by Empire would prevent the impairment of correlative rights or waste in the EMCU. So I'll give you that. So just to lay it out what the jury can look at, according to you. Number 2, what is Empire's applications? What are you asking for?
We're asking for the revoking of the 4 existing permits where disposal is taking place. We're asking that the 4 new applications be denied. And then the third matter would be moot if they revoke the 4 permits that are existing, then the request to increase the saltwater disposal from 25,000 to 40,000 barrels in the Dawson well would be moot and wouldn't have to be addressed.
Okay, and you believe there's enough evidence of oil in place in the San Andreas, correct?
Yes, sir. I think it's compelling evidence.
Okay, and it would be wasteful to leave that oil in place in the San Andreas, correct?
Well, our belief is that it won't leave it in the St. Andreas, that the pressuring up and the volumes of water going in are going to cause the ROS to migrate off of the lease and into adjoining lands and stuff, which would destroy the ROS potential for us to do a CO2 project.
Okay, so does it matter in the jury's calculation or the commission's calculation whether there's been a well since 1955 into the San Andreas? Should they weigh that at all in their calculations?
Well, recognizing that the unit wasn't formed till 1984 and that well was approved in 1958, I think it's going to be a stronger burden on us to try to get a decision from the commission on that operation. But the current disposal operations by Goodnight are the most significant impairing of our rights and creating the waste and violating the correlative rights is why we separated the hearing proposal to the commission to first have the hearing for Goodnight's operations and then at a later date evaluate and determine what proposal we would give the commission on the other existing wells within the unit.
Can the commission provide any weight to the fact that after the unit was formed, I think in 1984, this use still went on? Can they provide any weight in that in their deliberations?
Yes, sir. It just, the ROS concept wasn't something that existed in 84, and therefore there was no issue or concern about the injection the fracture study by Dr. Lindsay had not been done until the late 90s, 2000s and stuff. So the operators were not aware of the fracturing and the migration of the water up from the St. Andrews into the Grayburg. So I'm sure from your experience, you recognize the tremendous changes in technology during the last 45 years that I've been an oil and gas attorney, and things are ever changing. And when they change, you have to respond to that and accommodate that. So to have done that in 1958 or not being an issue in 1984, I think is reflective of just the fact that the technology and the science had not evolved to where there was a residual oil zone for tertiary recovery potential.
Okay. Assuming the commission determines that the permits issued to Goodnight were valid, can the commission provide any weight to Goodnight's reliance on the government's issuance of permits to them? Can they provide any weight to that in their deliberation?
No, sir, I don't believe that they can, because those permits were acquired fraudulently. The correct information relating to the pool, relating to their right to drill with surface leases and saltwater agreement leases are all invalid. So I would suggest to you that the commission, under no circumstances, would have approved those permits had they been aware of it being injected into the saltwater interval within the St. Andrews. And I think that that is something that y'all can go back and look at the division order at the point where that information was disclosed to the division, at which point the permit was denied.
If the commission does determine the permits were validly granted, do you think they can weigh whether Goodnight relied on the government in issuance of the permits?
No, sir.
Can the commission weigh some of the history about whether your organization and your predecessor organization should have known that Goodnight was there? Can there be any weight assigned to that?
I really can't speak to that, because we've had an issue finding evidence that they did know and could have objected. So that's an area that I can't respond to, sir.
Can the commission assign any weight to Goodnight's economic value in their company production? Can that be part of the weighing calculation?
Well, we've requested that they move the wells outside of the unit. And I don't want to put myself in a bind, but our chairman has mentioned at times that if Goodnight would do that, that Empire might even contribute to them drilling the new wells and moving them outside of our unit.
My question was, can the commission assign any weight to Goodnight's economic value and rights as a company in their production in these wells?
I'm not an expert in that, so I can't speak to it.
Can the commission assign any weight to the fact that Empire does not have a current application for the recovery of the ROZ at this time? Can they assign that any weight?
No, sir. I mean, the time that it takes for you to do primary and then secondary recovery and then move to tertiary recovery is not a 1 or 2 year span. It could take up to 10 years to get the approvals, get a pipeline for CO2 transportation, go in, remediate all the wells so that you can do a CO2 project, drill the new wells that have to be drilled to do a CO2 project would conservatively probably take 8 to 10 years. So the fact that we haven't made an application, it's just the fact that it's premature.
Can the commission assign any weight to the fact that your own consulting experts said there's fractures between the Grayburg and the San Andreas? Can the commission assign any weight to that evidence?
Yes, sir.
Okay. Can the commission assign any weight to a discussion about whether the ROZ is actually recoverable? Can they assign any weight to that deliberation?
Yes, sir.
Okay. All right. Thank you very much for helping us figure out what that jury instruction may look like.
Thank you.
Okay, thank you, Mr. Chandler. Let's see, it's 10:41. Why don't we go ahead and take our mid-morning break and we'll come back for redirect at, let's be back at 11. Oh, I'm sorry, Dr. Ampoma has one more question.
I do have one more question for you, and I forgot about that. So you
I thought I was finished.
No, just a quick one. So you talked about there was a discussion between Empire and Goodnight to move the operations to a particular distance where Empire would not protest. And even just now, you said even Empire was willing to support the drilling of those wells. Can you say to the commission, what distance are we talking about here?
What zone?
No, what distance?
Oh, outside of 2 miles of the EMSU unit boundaries.
And still injecting into the San Andreas?
Yes, sir.
Okay, thank you. No further questions.
Okay, mid-morning break. Let's recommence at 11. Are we ready to proceed in the back there?
Yes, we are ready.
So we have Ms. Tellez back with us. Thank you. All right, let's go back on the record. All right, so over the break, we decided, given the statements that have been made since cross-examination commenced, that we're going to give the parties another round at cross-examination. I'm anticipating a request that would be made anyway. So here are the options. You could redirect the witness now, Ms. Shaheen, or you could wait and redirect the witness later after a recross examination. Let me also add, if you elect to redirect the witness now, it doesn't mean you wouldn't get to redirect him again after recross, just so it's clear.
I'll do a redirect now and then again after recross.
Okay, perfect.
Mr. Wheeler, do you recall talking yesterday, I believe it was with Mr. Rankin, about the purchase and sale agreement?
Yes, ma'am.
And that purchase and sale agreement is with XTO, is that right?
Yes, ma'am.
And it's not with ExxonMobil.
Correct.
So the representations that you reviewed with Mr. Rankin, those were with respect to XTO, right?
Correct.
And not any you made no representations to Exxon. You made no representations to ExxonMobil about not relying on their opinions, correct?
Correct.
You relied on the representations of ExxonMobil with respect to the RAWs, the existence of the RAWs in the San Andres. Is that right?
Yes, ma'am.
Not XTO.
Yes, ma'am.
Do you remember, Ms. Owen, you know what? I might have some issues here making sure I'm able to share. Let me just double check. Okay. You remember Mr. Rankin asking you about some language in the testimony of Mr. West?
Yes, ma'am.
And he characterized that language as Mr. West's testimony that there hasn't been any production from the San Andres. Is that right?
Yes, ma'am.
Is Mr. Rankin's characterization of Mr. West's testimony accurate when reviewed in context? And I'm going to share that with everyone now. Is this the paragraph that you discussed with Mr. Rankin?
Yes, ma'am.
And Mr. Rankin referred to this last sentence in the paragraph, correct? Where it states that no wells have produced from the San Andres at EMSU?
Yes, ma'am.
And in context of the entire paragraph, including this first highlighted section, is Mr. Rankin's characterization of Mr. West's testimony accurate?
No, ma'am.
And why is that?
If you look at the first sentence there on paragraph 6, it states that relates to 1986, not to the life of the history of the operation of the MSU.
And there have been wells that were drilled into the San Andres after 1986, correct?
Yes, ma'am.
And 2 of those wells have produced oil from the San Andres. Is that right?
Yes, ma'am.
Do you recall which wells those are?
think the 660 and 658.
You were also asked by Dr. Ampoma about the San Andreas classification as an aquifer. Do you recall that discussion this morning?
Partially, I had this problem with my hearing aids, so I took them off. So it was difficult to totally understand what he was asking all the time. And in consideration of him, I tried to answer them to the best of my ability, but I've discovered since that he asked questions that I didn't understand and I answered them incorrectly.
Can you clarify Empire's position in respect to the San Andreas classification as an aquifer?
Yes, ma'am. We believe that it's within the unitized formation and is a productive residual oil zone.
And you were also asked by Dr. Ampoma whether you believed that the San Andreas was erroneously included in the unitized interval. Do you remember that question?
I didn't understand it. No, ma'am.
Well, can you please clarify Empire's position with respect to whether the San Andreas was erroneously included in the unitized interval?
Yes, ma'am. It is our position that it was not.
You also spoke earlier about this position of the state land office with respect to the applications at issue in this proceeding. Do you recall that discussion?
Yes, ma'am.
And have you refreshed your memory now at this time with respect to the state land office and its position?
Yes, ma'am. When I spoke to counsel who had had those conversations and stuff, I apologized to the Mr. Chairman in that I was incorrect, that there have been discussions, but there hasn't been an affirmative written or a verbal approval of that by the state land office.
You testified yesterday about a recent Texas case involving Goodnight. Do you recall that?
Yes, ma'am.
Is this the case that you were referring to?
Yes, ma'am. It's basic energy.
Basic Energy Services versus PPC Energy, is that right?
Yes, ma'am.
And when was this? This is an appellate opinion, is it not, from Texas?
Mr. Hearing Officer, I object to this line of questioning. I didn't ask, I don't know where, I mean, this is being elicited on top of, I'm not sure what gives her the right now to present this testimony or this evidence. This was not something I asked him about. I don't understand where this is coming from.
And OCD would join that objection.
All right, well, let's see where it's going first.
Can I ask, I mean, I don't understand what the basis is for Ms. Shaheen to present this testimony based on the questions that were asked by myself or any of the other council or the commission.
Where are you going with this, Ms. Shaheen?
Mr. Wheeler testified about this case yesterday, and the commissioners seemed to take an interest in it. We thought it would be helpful for the commissioners to see what Mr. Wheeler was testifying about. And counsel for Goodnight and for the division can cross-examine Mr. Wheeler on it in their recross.
Well, what's the point to be made from the case?
The point to be made is that the injection that Goodnight is doing here is occurring elsewhere and causing the same issues that Empire has raised in this matter.
Okay, well, it's getting close to not being factual testimony and you know, being offered in support of a legal opinion or conclusion. which I think is up to Mr. Chandler to advise the commission on. So unless you can lay more of a foundation for it, I'm inclined to exclude it.
Actually, the points that we would bring up would be factual issues that are similar to the factual issues here.
But Mr. Examiner, I strongly object to this. I did not question Mr. Wheeler on any of these issues. It's totally outside the scope of my cross. There's no factual foundation by anybody with subject matter expertise to establish any basis for Mr. Wheeler, who's a lawyer, to discuss any of these issues before the commission. This is in a different state, completely unrelated issues that have not been established, and there's no basis for Ms. Shaheen now to attempt to bring in additional direct testimony that is not part of his written testimony, wasn't part of the cross. It's completely outside the scope of what she should be permitted to do.
Mr. Rankin specifically asked Mr. Wheeler the name of the case that he was referring to, and then offered the name of a different case to ask him if that was the case that he was discussing. So it was the subject of Mr. Rankin's cross-examination, and I think it comes within the scope of redirect at this time.
Yeah, I don't think it does. I mean, the fact that a lawyer witness referred to an out-of-state precedent doesn't mean that Mr. Rankin brought it up and made it an issue in the case. If you guys think that it's relevant, again, as we stated, if at the end of this case you want to submit legal briefing and Mr. Wheeler thinks this supports Empire's position, it seems to me that's an appropriate place to, bring up extraterritorial legal precedent. So I'm going to agree and we'll exclude this at this time. And if you'll please move on.
Mr. Wheeler, you testified earlier about Goodnight's representations in its applications for its existing wells and its disclosure of only one pool code. What is Empire's position about what should have been disclosed by Goodnight to the division when it filed its applications?
That they should have included all three pools, the Eunice Monument oil pool, the Eunice Monument gas pool, and that would be under the order 7767, and then the 96-121 St. Andrews saltwater disposal.
Were there any other concerns about Goodnight's applications?
Yes, ma'am. They failed to disclose to the commission or the division that they had no rights to dispose into our mineral leased.
And does that relate to their surface agreement or their surface agreements or their lack of sufficient surface agreements?
Yes, ma'am.
Earlier, you talked about the plugging and abandonment and remediation liabilities that Empire assumed. Do you recall talking about that earlier?
Yes, ma'am.
And there was some discussion about specific numbers as to how Empire has recently determined a specific number with respect to that P&A liability. Do you recall that discussion?
Yes, ma'am.
And isn't it true that Empire knew when it entered into the purchase and sale agreement that it would have plugging and abandonment liabilities, right?
Yes, ma'am.
And that it was assuming all of the requirements to remediate if required or reclaim the sites and plug all of the wells. Is that right?
Yes, ma'am.
It was just in recent times that you've put a specific number on that in current costs. Is that right?
Yes, ma'am.
You were asked earlier about the status of filing the complaint against Rice and Owl. Do you recall that
Yes,
yesterday?
ma'am.
And has your memory been refreshed in regard to the procedural status of that case?
Yes, ma'am.
And can you tell the commissioners what the status of the complaint is? Has it been filed?
Yes, ma'am. It has been filed.
But it has not been served, is that right?
Yes, ma'am.
I pass the witness.
Okay, thank you, Ms. Shaheen. And I just would ask that the parties not go over territory that's already covered. It's a limited right to recross the witness on, new statements that have been made since you last cross-examined the witness.
Of which there were many. I apologize. I'm just there were a lot of statements and I'm working my way to ascertain, to your point, Mr. Hearing Officer, that I don't unnecessarily retread ground, and I apologize, but I'm just going to do my best to do it in a timely way. Mr. Wheeler, during your testimony, subsequent to my cross-examination of you, Dr. Ampoma was asking you about Empire's knowledge of the existence of commercial disposal wells in the EMSU, and you had a discourse with him about who was on site, whether anybody was there who would know about it, and you stated that it would be, impossible not to recognize that there were these wells being drilled if you were on site. You testified that the employees were contractors for XTO at the time. Is that correct? Who were on site?
I don't know if there were contractors or employees at the time.
Okay. When I deposed Mr. West, I specifically asked him about the employees who were with XTO, and who, if any of those employees came over to Empire after the acquisition. And Mr. West testified that, in fact, there were numerous employees of XTO, including the regional manager of the EMSU, who was officed in the EMSU on site, and that the field members, and I'm going to share with you on my screen the deposition of Mr. William West. And I asked him specifically, so some of the field members, do you see that on your screen?
Yes, sir.
So some of the field members are still there who previously worked with ExxonMobil. Yes. Would that include Toby Holland? Yes. And Mr. Holland, previously, as I previously inquired of Mr. West, was the regional manager. Who Mr. West testified was on site in New Mexico, and his duties and responsibilities included managing on site at the EMSU. Do you see that line of questioning with Mr. West?
Yes, sir.
Okay. Are you familiar with Mr. Holland?
I've met him.
Okay. So Mr. Holland was on site and was the regional manager for the EMSU for XTO and continues in that role with Empire, correct?
I would have to defer to Mr. West. I'm not responsible for any of the employees in the field, so I can't speak to who is or is not and what their current titles are.
Okay. Mr. Hearing Officer, I would ask to move the admission of the deposition of Mr. William West. In this case, was taken on December 4th, 2024. And I would move it as Goodnight Cross Exhibit number 18.
Are you asking to move into evidence the entire deposition? Or just the reference pages?
Okay, I'm afraid yes, the pages I would ask to be included into the record then would be pages on either side of page 40, so 39, 40, 41, and then 53, 54, and 55.
Empire objects to admitting any deposition testimony into the record. Mr. West is next up as a witness, and Mr. Rankin can cross-examine him about these statements.
Why don't we wait till I expect you'll go there with Mr. West. Why don't we wait till then?
Okay. Mr. Wheeler, yesterday when I was crossing you told me that the managers who were responsible for the acquisition and management of the EMSU and the properties in New Mexico were fired, correct?
I'm not sure if that's the correct terminology. They were either terminated or left,
Okay.
but they're all gone.
And why were they either, why was it that they were either terminated or left?
Who left or who terminated them?
Well, my question is, why were they terminated or why did they leave?
I wasn't here at the time and wasn't involved in those actions, so I can't speak to that.
When did they leave, Mr. Wheeler?
They had all left prior to me coming to work for Empire in September of 2023.
And I think you testified that Empire found out about the SWDs in August of 2023. Is that correct?
Yes, ma'am.
Okay. Or at least Empire's management. And you referred to that as Mr. Mulechek, is that right?
Yes, sir.
But Mr. Morissette was there continuously from the time of acquisition and continues to be there, correct?
Yes, sir.
And he's the president of the company, correct?
Yes, sir.
Okay. So you don't know, I mean, if it was discovered in August of 2023 and they had been gone by the time you joined in September 2023, they would have been separated from the company prior to Empire discovering that there was SWDs on site, correct?
For the current management of Empire, yes, sir.
Okay. You discussed with Mr. Ampoma or Dr. Ampoma the fact that you're aware that Goodnight Midstream has a pipeline that's you used about 67 miles, correct?
Yes, sir.
And that pipeline services produced water from the Delaware Basin, correct?
That's my understanding.
And if that pipeline if Goodnight's wells are shut in, then those operators in the basin who are supplying produced water for disposal through Goodnight's wells would either have to shut in their production or find alternative disposal sources, correct?
Correct.
Okay. And that could have an impact on their ability to continue to produce and generate revenue and oil and gas reserves in the basin, correct?
Correct.
And that would be true for any of the other wells in and around your units within 2 miles that are servicing production in the Delaware Basin, correct?
Probably, yes, sir.
Okay. And not just the Delaware Basin, but production in any offsetting tracts that are reliant on those disposal wells for their production, correct?
Correct.
Who did you speak with at XTO about whether or not XTO was aware of Goodnight Midstream's disposal operations in the EMSU?
I spoke to Mr. Walker, who's the division geological manager at XTO. And then I spoke with a Miss Pierce at ExxonMobil. And I don't remember the names of the other couple of people that I spoke to.
As part of your information gathering with XTO, do you keep records?
So I keep records.
Did you communicate with these folks through emails?
I'm sorry, could you repeat that?
Did you communicate with these folks at XTO through email?
No, sir.
By phone?
Yes, sir.
At what time did you talk to those folks at XTO?
Probably May or June of 2024.
Was Mr. Walker do you know if Mr. Walker was the manager of whatever division you referred to at the time the Goodnight applications were filed?
Yes, sir.
And was he?
Yes, sir, he was.
Okay. Mr. Wheeler, you had a discussion with Dr. Empoma, apologies, about your understanding of Goodnight's legal rights to inject into its disposal zone. Do you recall that discussion with Dr. Empoma?
Yes, sir.
And it's your position that the agreements that Goodnight Midstream has to inject into the San Andreas disposal zone are not legally valid, correct?
Or not what?
Are not legally valid for their purposes, correct?
Yes, sir.
Okay. But you're not saying that Goodnight Midstream doesn't have agreements, correct?
In response to a subpoena that we served Goodnight, the saltwater disposal and surface lease agreements that we received and what we've been able to discover checking the county records in Lee County, none of those are proper and correct. So I'm not aware that there's other surface leases or saltwater disposal agreements, but if there are, you could furnish them to me, I could respond.
So my point though, Mr. Wheeler, is that you have a legal position that those agreements that Goodnight has in place are, in your opinion, not valid, correct?
Correct.
Okay. And it's not you're not saying that they don't have agreements. You're saying that you believe they're not valid, correct?
Correct.
Okay. Now you reviewed the Piazza case transcript and testimony, correct?
Correct.
And you're aware that as part of that case, Goodnight Midstream did present to the division evidence of what it in good faith believed was a valid right to inject, correct?
I saw the testimony of Goodnight's position, but I didn't see anything where the commission concurred with that.
I'm sorry, I couldn't hear the last bit you said.
I didn't see anything from the commission's order that they concurred with that.
Okay. But you reviewed the entire Piazza record that was presented to the division.
Yes, sir, I did.
Okay. But you're stating here now to the commission that you just didn't see anything where the division addressed that issue, correct? Address the issue of whether or not there was any dispute over the right of Goodnight to inject into the disposal zone.
That's right, I don't recall.
Okay. But you agree with me that the division and the commission don't have authority to adjudicate private property rights?
Yes, sir.
Okay. And all the statements that you've made subsequent to my cross-examination of you about the Empire's positions regarding the technical issues around the dispute in this case were all based on your understanding of of the company's position and the experts that Empire is presenting in this case, correct?
Yes, sir.
Okay. And it's not that you have the expertise to make those separate and independent assessments yourself, correct?
Correct.
For example, I mean, I think you told Dr. Ampoma that you believe that could be a 40% recovery of hydrocarbons from the RZ in the MSU. Is that correct?
That's what I've heard in meetings.
Who have you heard that from?
I don't recall exactly.
Okay. Is Mr. West going to testify that there's going to be a 40% recovery of hydrocarbons from the San Andres ROZ?
I have no idea.
Okay. But you gave a number that you believe Empire believes that it can recover between 350 and 375 million barrels from the San Andres ROZ. Is that correct?
You say 200?
Yeah.
350 to 375 million.
I object. I believe Mr. Rankin is
I'm sorry, what was the number again?
I had written down, I'm asking for clarification. I'd written down the numbers 350 to 375 million barrels of recoverable hydrocarbons.
That's what my notes reflect.
That's correct. But Mr. Wheeler also stated that that was his opinion, if you will, as a lawyer, that he has not done any work and whether that factor is appropriate here. And I believe he testified that that recovery factor is one that was used in other ROZ fields in Texas.
Mr. Rankin, why don't you rephrase the question?
Well, I just want to make sure my notes were correct. So I was asking Mr. Wheeler just to confirm that whether or not it's Empire's position that this project will recover between 350 and 375 million barrels of hydrocarbons from the San Andres RZ. I just wanted to make sure I understood that. And he can qualify it.
Any objection to that rephrased question?
I don't believe Mr. Rankin's recognizing the fact that Mr. Wheeler was talking about that number as a result of it being used or applied to other fields in Texas. He was not referring to the EMSU. He merely stated that if that recovery factor applied to the EMSU, then his calculations would be that there would be approximately 350 million barrels of oil recoverable from the EMSU.
Okay, overrule the objection. Why don't you state the question again?
Mr. Wheeler, I'm just asking for clarification on the company's position because I wrote down in my notes what I understood you to say was Empire's position on what it thought would be recovered from the San Andres RRZ. And I just want to make sure I understood. Because I think I've also seen similar numbers in the briefing and filings that Empire has filed before the commission. And I just am trying to make sure I understand it. I thought I heard you say that Empire believes, in response to a question from Dr. Mpoma, that they can recover between 350 and 375 million barrels of hydrocarbons from the San Andres RRZ.
No, sir.
Okay, what was it that you said?
But I said my opinion.
Okay.
So I'm not a reservoir engineer or production engineer. I don't have the expertise to state what Empire's position would be.
Empire acquired this property in March of 2021, correct?
Correct.
And it bought the property with the intent of pursuing a residual oil zone development across the EMSU and the other two units. Agree?
Correct.
And from the time it bought the property until this date in April of 2025, has it undertaken any efforts to identify or further define or delineate the potential ROZ across any of those three units?
No, sir. Like I stated yesterday, we've suspended all operations until we get a determination if Goodnight's going to be able to continue to inject water and destroy our productive interval.
So from March of 2021, when it acquired the property, until it suspended operations late in the summer of 2023, Empire did nothing to evaluate or further delineate its plans to pursue an ROZ development in these three units. Agree?
I wasn't with Empire at that time, so I can't speak to that.
Are you aware of anything that Empire has done in that period of time to undertake any efforts to delineate a potential ROZ in any of those three units?
I don't know what the predecessors at the company did.
Well, you spent a lot of time getting yourself familiar with a lot of materials as part of this case. In fact, I understand that you were hired based on your testimony to address this specific issue with Goodnight Midstream, correct?
Yes, sir.
And as part of that effort to get up to speed on the disputes with Goodnight Midstream, you're not aware of anything that the company did prior to suspension of operations in 2023 to further delineate the ROZ in any of these three units?
No, sir, I'm not.
You testified in response to a question from Dr. Mpoma that you believe that Empire believes, or I understood you to say that Empire believes that you have enough evidence to date to determine whether or not there are recoverable hydrocarbons in the San Andres ROZ. Is that correct?
Yes, sir.
Okay. Now, when Empire now has prepared AFEs for all three of these proposed APDs that it's looking at potentially drilling, is that correct?
I would have to defer to Mr. West on that.
I have in my notes that you looked at AFEs for all three wells, is that correct?
No, sir, I had not looked at them. I know that preliminary AFEs were being prepared and there were meetings about the coring, all of those kinds of matters, type of pipe in the well, all that kind of stuff. But I would have to defer to Mr. West for the specifics of that.
Okay. You gave an estimate of cost for $800,000 for all coring. That would be for all three wells, correct?
No, sir, I was understanding that that was for one well.
Okay. And that price was that including drilling or just for the coring operations?
It's my understanding that was the cost that if they did all the various types of coring, that's how much it could potentially cost.
And my question is, did that cost include the drilling of the well or just the coring operation?
Just the coring.
Do you recall what an estimate of cost was for the drilling of a well?
No, sir.
Mr. West would know that.
Yes, sir.
Recognizing that the company has concerns about the impacts to the EMSU from Goodnight's injection, has Empire evaluated going forward with any ROZ testing or pilot projects in the, for example, AGU unit to the southeast?
Not to my knowledge yet.
Why not?
Because our focus has been on the MZU primarily.
Okay. Is there anything stopping Empire from pursuing and evaluating a potential ROZ in the San Andres in the AGU?
Not to my knowledge.
Okay. You discussed, Mr. Moander, and the division's concerns about impacts to the Capitan Reef and through the Hobbs Channel. Has Empire done anything to evaluate those concerns since they were raised by the division?
Yes, sir, if you'll recall in Dr. Lindsay's testimony, he stated that there was no communication with the Hobbs Channel or moving the water into the El Capitan Reef.
And so to the extent that remains a concern of the division, is Empire relying solely on the testimony of Dr. Lindsay?
Yes, sir.
Mr. Wheeler, you and I had a discussion yesterday about your testimony that there were some communications between Empire and Goodnight Midstream. And you again raised that discussion again in response to questions from Commission Counsel. And then you addressed an additional point about, I believe it was Mr. Mulechek stating that Empire be willing to contribute costs to drilling new wells outside a 2-mile radius of Empire's units if Goodnight would agree to withdraw its applications and injection within Empire's units. Do you recall that?
I'm going to object because I believe Mr. Rankin is again misstating
I'm asking.
Mr. Wheeler's testimony.
I recall the discussion. It sounds fairly close.
Well, I don't believe there was any discussion about Empire contributing cost to Goodnight moving wells outside of the 2 miles from the MC.
I actually distinctly remember that, so I'm going to overrule the objection.
Mr. Wheeler, I'm asking for clarification on a couple points, okay? Number one, will you clarify what it is that you understood your board chair to be offering?
In discussions about how to move forward with a resolution, that was one of the matters of multiple matters that were discussed, that there were other issues and stuff that had to come into play for evaluation.
My question, Mr. Wheeler, first was, will you clarify what what was being offered, or your understanding of what the offer was?
This was a discussion of which a number of managers, executives, and engineers of Empire were present. There was no offer formally made to Goodnight.
And on that point, Mr. Wheeler, have you had a chance to, I mean, yesterday you testified that there was a response made to Goodnight based on of some type. And I'm asking you now, because you brought it up again in your discussions with Commission Counsel, who communicated? Were there any communications directly between Goodnight Midstream and Empire, to your knowledge?
Those were the discussions between Mr. Padilla and yourself.
Are you aware of whether Mr. Padilla provided any response from Empire to me?
I'm not knowledgeable what those discussions were. I was just told that there were discussions and that they got nowhere with them.
Okay. So you're not aware of what Mr. Padilla may have, or even if he had responded to me in any way, correct?
No, sir.
Okay. You're not aware, correct?
No, sir. No.
Mr. Wheeler, you testified about representations. You understood the representations that were being made during the purchase process between XTO and Empire were being made by ExxonMobil. Is that correct?
Yes, sir.
But yesterday I showed you Empire's own exhibit from the Piazza case where it the cover page of the data room sheet says XTO Energy. Do you see that?
Yes, sir, I saw that.
I'm sorry. Put that on the screen. Thank you. And in fact, every single page on this exhibit that was the open offer for the data room identifies XTO Energy, doesn't it?
It identifies, but I know for sure that the data room was an ExxonMobil data room, not an XTO.
And doesn't the disclaimer directly identify XTO?
Yes, sir, and that's what we spoke to. It doesn't include ExxonMobil.
But the representations being made in this document are from XTO, correct?
Well, there's another document where representations were made by ExxonMobil.
Were you confused? I mean, you weren't there at the time, but were you confused by who was making what representations?
Once I came aboard and reviewed the first brochure that I showed you from ExxonMobil, there was never any doubt in my mind that those representations were from ExxonMobil, not from its subsidiary XTO.
Mr. Sorry, it's getting on my. Dr. Ampoma had some dialogue with you about whether you believed whether you agreed that it was improper at the time that the EMSU was created, that it included the San Andreas interval. Do you recall that?
No, sir, I had my hearing aids off because of the noise, and I didn't understand his question, so I didn't answer it as to what I thought he was saying and what he was actually saying. I misinterpreted his question.
Okay. But during the course of your discussion with Dr. Ampoma, you agreed that at the time it was recognized as an aquifer, correct?
No, sir, I didn't.
Okay. So when you were asked by Ms. Shaheen to clarify the proper characterization of Mr. West's testimony, where I pointed out that in Mr. West's testimony, he had testified that there was no production in the San Andreas. And you testified that it was it was taken out of context. Do you recall that?
Yes, sir.
And you stated that the proper context is to understand that there was no production from the San Andreas in 1986. Agree?
Agreed.
Okay. And if there was no production in the San Andreas in 1986, then how could the commission have authorized the inclusion of the San Andreas in a unit if one of the requirements of statutory unitization is that any pool or portion of a pool be reasonably defined by primary production?
I can't speak to that.
Okay. But you don't disagree that there was, as of 1986, there was no production, as Mr. West is testifying here, as of 1986.
Yes, sir.
You reviewed, and again, you made this statement to the commission today. Your position is that Goodnight Midstream fraudulently filed its applications with the division, correct?
Correct.
And the basis for that claim is that they failed to accurately or properly represent the formation into which they were proposing to inject, correct?
Yes, sir.
Having a hard time pulling up something that I would wanted to present to Mr.
We may be having some connectivity issues. I all of a sudden lost some connection, so I'm unsure what's going on, but I can say that I'm struggling with some.
Mr. Hearing Officer, maybe since there are some issues, we call for lunch right now and then reconvene.
That sounds like that's makes sense. Let's break for lunch. Mr. Rosatos, what's the commission's preference on the lunch break?
Yesterday, you want to do 1:15, 1:30?
Sure. As a feet to the fire kind of hearing officer, I would pick 1:15, but if you'd prefer 1:30.
1:15 is fine. Thank you. We'll meet back at 1:15.
Okay, thank you all.